Right. Good morning, Mr. Goldberg.
Morning, my lord.
Can I, before you start, can I say we've had the opportunity to read, as you might imagine. Thank you very much for your skeletons and materials. Have you decided between you how you're going to divide up the time?
I've got today. My learned friend has until 3:15 tomorrow.
And then a short reply. Well, we hope we might be able to finish a little earlier than that, but let's see if we can make it a case where the submissions don't expand to fill the available time.
I'll endeavour to do my bit.
Over to you.
My lord, my lady. Mr. Justice Rowlatt was a judge who knew a thing or two about tax, and he had an unerring instinct for the right answer. In Warnes, which is a case which we added to the authorities bundle rather late, but I hope you have it, at page 452, he said this: Warnes is a case like Von Glen. It's about a fine, and he's saying it's not deductible. And this is his explanation of why it's not deductible. He says, I think that a loss connected with or arising out of a trade must at any rate amount to something in the nature of a loss which is contemplable and in the nature of a commercial loss. That sentence expresses in characteristically free-flowing form a truth about how profits should be determined for tax purposes. And in our submission, it unlocks the key principle to be implied in cases like this, where the aim of our tax law is to find the true commercial profit, which is to be the subject of taxation. And we can see that in the NCL case, which is in the bundle of authorities at tab 11.
Now, I have to say, I don't think that authority, by the way, the first authority you cited to us, has reached its way to me, at least. It may well have reached its way to us.
It came in soft copy.
Okay, so
We have hard copies available if you would like.
if you've got hard copies, it probably would be sensible. So,
Can I just ask during the pause, is there a transcript running of this
No,
appeal?
we didn't. The plan was to request a transcript after the event.
Thank you. So there's not one running currently?
No.
Thank you.
I haven't got one either.
Warnes.
Hasn't got to me yet.
as always, my lady is ahead of us.
I suppose it illustrates that things go wrong even in the best organised arrangements. So, NCL is a recent Supreme Court case, tab 11 in the bundle of authorities, about the computation of profits and the importance of the accounts. And I'll come back to it later, but at the moment I just want to point out a passage at the bottom of page 238 of the bundle. The last sentence. This is a quotation by the Supreme Court from Vice-Chancellor Pennycook in Odeon Associated Theatres. And he says, the concern of the court in this connection is to ascertain the true profit of the taxpayer. That, and nothing else, apart from express statutory adjustments, is the subject of taxation in respect of a trade. In so ascertaining the true profits of a trade, the court applies the correct principles of the prevailing system of commercial accountancy. And he goes on to explain that. And at page 239, at the bottom of in paragraph 22, Lord Hope described computation of profits in accordance with the currently accepted accounting principles as being the golden rule. The golden rule is that the profits of a trading company must be computed in accordance with currently accepted accounting principles. They are the best guide as to a true and fair view of the profit or loss of the company in the relevant accounting period. Profits so computed are subject to any adjustment required or authorised by law in computing those profits for corporation tax purposes. But there is no rule of law that prohibits effect being given to what currently accepted accounting principles provide as to how a true and fair view is to be arrived at. So that is the aim of our tax law. It is to find the true profit, true commercial profit.
Yeah, I don't think any of that's in dispute, is it, Mr. Goldberg? The question is whether this would be an adjustment that would be required by law.
Yes, but at the moment there is no authority, no binding authority that says it is an adjustment required by law.
I understood that that's your submission.
Yeah.
And while we're here, it's 29, is it, I think, that I think HMRC make this point. 29 recognises at letter C the possibility of a judge-made rule.
Yes, of course. But nonetheless, it would be surprising if the judge-made rule allowed you to tax something that wasn't a true profit.
Well, it depends what you mean by judge-made rule. If by that you mean a judicial interpretation of a parliamentary statute, that's not a judge-made rule.
No, I appreciate that. But one of the questions that arises here is whether we're looking at a public policy question or whether we're looking at an interpretation question. And the tribunal, the First-tier Tribunal, treated this as entirely a policy matter. The Upper Tribunal says it's an interpretation matter. But which bit of the statute are they interpreting? They've been singularly silent as to that. And in my submission, if it is an interpretation matter, it's an interpretation of the word expenses, wholly and exclusively incurred. And Mr. Justice Rolat here is telling us that the question is whether it's a commercial expense or not.
Would Lord Hoffman have agreed with you?
Oh, I'm sure Lord Hoffman would have agreed with me. Lord Hoffman was addressing fines and penalties in a strict sense, and he's not saying anything about payments which are not fines or penalties.
He was interpreting the legislative intent behind the statutory, the statute that enabled penalties to be levied.
Well, your Lordship has extracted more from what Lord Hoffman said than I've been able.
Well, perhaps I should put a question mark at the end of that intervention and see whether you can deal with that when we go to Matt Knight.
Yes. It's rather unclear, if I may say so, exactly what Lord Hoffman is saying applies to what. Perhaps I can look at it later. Certainly, the principles of profit determination do not respond to sticking a simplistic label on the payment. And the search here is for a commercial truth. It is not for a legal fiction. And if I may say, to say that the payments made in this case were penalties is a legal fiction.
I don't think anybody says they were penalties. I think the question is whether they are to be regarded or treated in the same way as penalties if they were imposed in lieu of penalties. I don't think anybody actually says they are or they were penalties. I think it's clear that they were payments arrived at in lieu of penalties.
There were no penalties for them to be in lieu of.
There would have been. I think the argument is there would have been, and or at least, well, again, perhaps we'll look at the. Perhaps we should look at the relevant basis for the agreements. Anyway, we're busy sort of mapping out the battle lines as we go. Perhaps we'd better let you get into your arguments.
Well, I hope that my argument will address the points that my lady and your lordship have put to me as we go. In our submission, Mr. Justice Rolat's suggestion is that you should ask in relation to a payment, can you contemplate making payments like the redress payments in the course of a trade without the intervention of the regulator?
Sorry, I'm probably being slow. How do you get that exactly out of what Mr. Justice Rolat said?
I get it out of contemplable.
Contemplable?
Yes, he says. Is the expenditure contemplable?
Are you suggesting that all or just some of the payments here might meet the test as you've just described it?
I could divide up the payments made to the consumers and the payments made to charity, but I think more accurately it's right to say that what I'm saying applies to all the payments.
So the way you pose the question is whether it can be contemplated that the payments will be made in the course of a trade without intervention of the regulator.
Yes.
Well, we haven't got any, as far as I'm well aware, findings of fact to that effect.
But we do. Perhaps I could take you.
Okay, well, take your own course in your submissions, but it's not immediately obvious to me that these payments are ones that one would contemplate being made without the intervention of a regulator.
But I hope to make it obvious immediately by going to paragraph 60 of the FTT Tribunal, tab 12 in the core bundle. So paragraph 60, Spur agreed that it had breached the requirements. Before the negotiations had started, Spurl had written off some 8 million of consumers' bills in recognition that it had breached its duties and in recognition of consumer harm. Now, there has been no challenge to the deduction of that £8 million. And it would be absolutely astonishing if it were challenged, and absolutely astonishing if the court were to say that it was challengeable. It is quite obviously an ordinary business expense, the type of thing that arises all the time in business. So the point to grasp and to hold on to is that, like the 8 million written off, the redress payments are ordinary commercial payments which share with the 8 million written off at least the following 8 commercially contemplable features.
Just out of interest, where do we actually have a finding that that 8 million was set against profit? No challenge to it.
We don't have that finding, but it certainly was not challenged.
Okay, I mean, it didn't form any part of the reasoning in either.
Well,
at either level, did it? I mean, it's a point you're entitled to make, but I don't recall that as having featured anywhere in the reasoning of either FTT or Upper Tribunal.
Well, it comes. Perhaps I can take you through the decision. If I take you through the 8 features that I want to draw attention to, and we'll see what the First-tier Tribunal said about them. But
and sorry, just before we start, you're using the term redress payments. That's the term that the FTT used to cover all these payments. Are you when you're I just want to clarify, when you're referring to redress payments, you mean the whole in aggregate 28 million, do you?
I do, because they were all paid to recognise harm suffered in the carrying on of the trade by the consumer, although only part of them went. Perhaps I can run through the 8 features and then come back and show you what the tribunal said about them. So, first of all, they were made under agreements and accordingly involved choice. We don't actually know what would have happened if Scottish Power had not agreed a settlement with its regulator. A penalty was not automatic. Scottish Power could have appealed and might have ended up paying nothing. And that appears from Section 27E of the Electricity Act, which I'll be coming back to. It's in the Authorities Bundle, tab 1, page 14.
We don't know, but didn't the FTT make a finding about that at 137 as to what would likely have happened?
They said it would likely have happened, but that doesn't mean that they know what would have happened.
No, but isn't it a finding by them as to what would have happened? That's how the Upper Tribunal interpreted it, I think.
That, yes, but we don't know how much it was, or what it would have been, what its terms would have been. So the first point I make is they involve choice. The second point is that they lack the element of compulsion. The third is that they arise from the normal course of the relationship between consumer and supplier. They are in most cases unavoidable.
Well, those two are two different propositions. I don't know whether you've now moved on to a fourth proposition, or whether you've put both those propositions under the same heading. I mean, I understand your submission that they arise from the normal course of the relationship, but the second limb to your proposition, if that's what it was, is a very different point, isn't it?
It's a different point. It's my fourth point.
That's your fourth point. Okay. Yes. So you may have to unpack that a little bit.
I'm going to unpack all of these.
Good.
I'd just welcome the opportunity to put them on the table. The fifth one is that they are made to benefit consumers. The sixth point is that they're payable to remedy trade wrongs and not as a fine or penalty for the breach of a relationship between the citizen and the state, or the citizen and an authority or regulator, which can generally, though not always, arise irrespective of whether there's a trade or not. Unlike fines and penalties, they are not paid primarily to satisfy the wider requirements of society or public interest. So that the taxpayer can have had a business purpose in incurring liability to pay them. And lastly, they were not paid in lieu of a penalty and cannot have been paid in lieu of a penalty because there was no penalty for them to be in place of. It's nothing to the point that if Ofgem had gone through a rigmarole, it might have been successful in imposing a penalty. What that means is that the payments were in lieu of a rigmarole, not in lieu of a penalty. Now, can I show you in the First-tier Tribunal's decision passages that I say support those points? So it's at tab 12 in the core bundle, and I start at paragraph 35. SCPL was not compelled to make a settlement agreement by force of law or physically. It could, in every case, have refused to settle and either accepted a penalty or appealed against a penalty imposed by GMA. But in each case, it chose to make a settlement in negotiated terms under which there were obligations to make the redress payments. It did so for the following reasons. Settlement avoided the risks inherent in litigation, the possible adverse effect on its reputation of a large penalty, and the diversion of management time in bringing the investigation to a close by litigating the penalty. Settlement avoided adverse publicity and damage to SCPL's brand and maintained goodwill with Ofgem. Redress payments made to customers promoted goodwill with them, and settlement tended to compensate and could, where possible, be directed to those who'd suffered harm. SCPL preferred to make payments for the benefit of consumers rather than paying money to the exchequer. It's an important point, by the way. Had there been a penalty, it would have gone to the consolidated fund. Here it didn't. Then at paragraph 109, the First-tier Tribunal was asked to make a finding that the redress payments were made under and in accordance with the settlement agreements, and they found that. It's not paid under some form of statutory obligation. And they were asked to find SPEL's entry into each of the settlement agreements was voluntary and was the result of negotiation. They find, to the extent that voluntary means without compulsion, by force or by law, we so find the terms of the settlements and the amounts of the payments were the result of negotiation, as the history of the mis-selling agreement and the reduction in the amounts originally suggested by Ofgem show. And by the way, those facts relating to the reduction of the penalty show that the payment of a penalty in the amount originally claimed by Ofgem was by no means certain. The agreements were not imposed on the appellants. They agreed to their terms in the expectation that if they did not, a penalty greater than £1 would be imposed. I think what that really means is would be claimed, and there would then have to be an appeal and a hearing, because there's no way that a penalty just gets imposed. And then a very important finding at paragraph 119.
Oh, sorry, when you say it's no way it's just imposed, it is imposed, it's just that your clients have a right to appeal it.
Well, I think since when they appeal, they're not liable to pay the penalty until the result of the appeal is known. I think it's more accurate to say that the penalty is claimed.
You'll be taking us to the statutory framework at some point.
I shall. Yeah, I will. I'm not going to do it now.
You were going to 119, I think.
Yeah. So I was asking them to find the redress payments were made for the same purpose and had the same consequences for SPEL as all other compensation payments made by SPEL, whether in accordance with its published complaints handling procedure or by agreement or otherwise. Generally, we consider that compensation payments made by SPEL in accordance with its published complaints handling procedure or by agreement, ordinary compensation, will be expenses incurred in the activities and for the purposes of the trade. In the case of the redress payments, it seems to us that whilst they were incurred in the course of activities carried on for the purpose of the trade, they were also made for the purpose of closing down the investigation and avoiding adverse publicity, and so differed from ordinary compensation. But it seems to us that those two purposes were like those of the settlement agreements in Great Boulder, both purposes of the trade. So the ordinary compensation paid by SPEL in the course of its trade has exactly the same purpose, although the redress payments have additional purposes. But the redress payments include the same purposes as the ordinary compensation. I rely on the same passages to conclude that the settlement agreements lack the element of compulsion. The redress payments are paid by agreement, not under compulsion. Then my third proposition was that they arise from the normal course of the relationship between consumer and supplier. And I go to paragraph 112 for that. accept that the essence of Spurl's trade was selling gas and electrical energy. We accept, for the reasons set out below, that the acts or inactions which gave rise to the redress payments were part of that trade's activity, and that they were done for the purpose of earning income from that trade. We find that the payments were a consequence of not meeting the standards required of energy suppliers. We express no opinion as to whether those standards are high. We find that infraction of the standards is not uncommon, but that serious breach, as was the case in relation to the redress payments, is less common. We consider that the breaches of the CO2 and complaints handling rules are practically almost unavoidable. We're not able, on the evidence, to say the same in relation to the mis-selling or cost reflexivity. But the court will, of course, appreciate that the complaints handling payments are by far and away the largest payments here, and almost unavoidable. So that certainly establishes that the payments arise from the normal course of the relationship between consumer and supplier.
I mean, do you say that that's a finding that every breach of complaints handling rules is practically unavoidable, or that some breach?
Some breach is practically unavoidable.
It'd be quite a submission to say that every breach of the claims handling rules is unavoidable.
I'm not making that submission, but I do make the submission that the breaches in relation to complaints handling were practically almost unavoidable. That is what the First-tier Tribunal held.
Well, it held that these particular breaches of complaints handling were almost unavoidable, or words to that effect.
Well,
and that's around 18 million, is it?
Yes. It's by far and away the biggest part of this claim. And my clients are entitled to have their claim looked at one by one. The Upper Tribunal says, oh, well, we'll do one overall great big lumping together operation. And, oh, gosh, we don't like this very much, so we're not going to allow a deduction for it. Doesn't do what my client is entitled to do, to test each claim for a deduction. And you would have thought, you might have thought, that if error is almost inevitable in the course of a trade, and you have to pay because of the error, that you could not be drawing up a true commercial profit and loss account that did not make provision for the expense of remedying the error. My next point was that they're made to benefit consumers. And we see that from paragraph 35 of the FTT decision at C. Settlement tended to compensate and could, where possible, be directed to those who had suffered harm. But we also see that in the papers put out by Ofgem in the supplementary bundle. At tab 8. Page 166. I should perhaps explain that there are here settlement agreements. Ofgem then put out a draft notice, and finally they issue a decision notice. I'm taking you to the final document in that process. At tab 8, this relates to complaints handling. And we see at page 166, there is a summary. Having considered all the circumstances of the case, I'm picking it up at 1.4, the authority considered that the consumer redress payments will be of greater benefit to consumers than if a significant financial penalty were to be imposed. Accordingly, the authority considered it appropriate in the circumstances of this investigation to impose a reduced financial penalty on Scottish Power, provided that Scottish Power pays the sum of 18 million less £1 in consumer redress on the dates and in the manner set out in paragraph 1.6 below. The consumer redress will be, and there's a footnote, consumer redress for the purpose of this notice refers to redress to customers who are domestic customers as defined in Standard License Condition 1, Standard Condition of Gas and Electricity Supply licenses. And the 18 million should be used in the following manner: to make compensation payments totaling up to 15 million to Scottish Power's affected Priority Service Register, PSR and Warm Homes Discount customers who were either due a bill that became more than 6 weeks overdue between the date of 1st April 2014 and 31st March 2016, or made a complaint to Scottish Power about an issue arising out of Scottish Power's migration to a new IT system between 1st April 2014 and 31st March 2016. And it might be worth looking at 1.9 to see what provision is breached. SLC 25C is a principles-based condition that covers behaviours and actions of suppliers when dealing with domestic customers, the provision of information to domestic customers and the effectiveness of customer service arrangements. Specifically, the SOC requires suppliers, among other things, to take all reasonable steps to achieve the following: behave in a fair, honest, transparent, appropriate and professional manner, provide information that is complete and accurate and not misleading, and which is otherwise fair both in terms of content and in terms of how it's presented, and C, be easy to contact, act promptly and courteously to put things right when suppliers make a mistake, and otherwise ensure that customer service arrangements and processes are complete. So that's what they're supposed to do.
So you were reading from somewhere there. Did you give us the did you give us the reference?
1.9.
1.9. I did. I'm sorry.
Sorry, I just missed it. Yep. Thank you.
As I did, judging by my own dealings with British Gas, the sort of errors that are referred to at paragraph 1.9 happen all the time. I send them a photograph of my meter with the reading on it, and they write back and say, this meter is in an industrial park in Sheffield, which I can assure you is not where it is. it is just a matter of everyday experience that this sort of thing happens. And the authority's decision is at paragraph 6 on page 183. And they've gone through a whole pile of errors and so on, not in any way trying to belittle them, but they are all the sort of things that inevitably are going to happen in the course of running a trade. And the authority says, taking account of all these factors, and also mindful of its principal objective to protect the interests of existing future energy consumers, Scottish Power has agreed to pay 18 million less a pound in lieu of a higher penalty. The authority hereby imposes a financial penalty of £1 on Scottish Power in respect of the breaches it finds of the standard licence conditions mentioned. It considers the penalty to be reasonable in all the circumstances of the case. I draw attention to that. £1 was the penalty that the regulator thought was reasonable. Taking the following factors into account.
Do you read the phrase, Scottish Power has agreed to pay £18 million in lieu of a higher penalty, as meaning the penalty would have been higher than £18 million or higher than a pound?
I don't know how I read it. It could mean either. What I do know is perhaps
perhaps break my Lord's question down. Do you think it could mean in lieu of a penalty of more than £1?
Certainly, yeah.
Okay.
I'm sure it means that.
So the real question is, was it considered to be in lieu of a penalty of more than 18 million?
It could have been. And I don't know what Ofgem would have done. We haven't brought it, but there is a case where Ofgem claimed a penalty, and the Court of Appeal reduced it very, very substantially.
I suppose my Lord's question to you is fair, given that this is aimed at your client's agreement. Scottish Power has agreed to pay £18 million in lieu of a higher penalty.
I don't know. I don't know what penalty they expected Ofgem to impose if they hadn't entered into the agreement. It might have been 18 million. It might have been more than 18 million. We don't know, because that isn't what happened. And if the court says, well, it could have happened, that, in my submission, is computing profits according to a legal fiction and not according to the commercial reality. What we know is that we could have appealed against any penalty that was suggested. Perhaps I should show you the legislation relating to penalties. It's in the authorities bundle. At tab 1, And at page 10, at section 27A3, well, maybe we should start at 27A1, where the authority is satisfied that a regulated person has contravened or is contravening any relevant condition or requirement, or is failing to achieve any standard of performance prescribed under section 39 or 39A, the authority may, subject to section 27C, impose on the regulated person a penalty of such amount as is reasonable in all the circumstances of the case. 3. Before imposing a penalty on a regulated person under subsection 1, the authority should give notice stating that it proposes to impose a penalty, the amount of the penalty, and so on. And then there are rules as to what it has to do with the penalty. 27A5 provides that as soon as practicable after imposing the penalty, the authority must give notice setting out the details, including its amount and the date by which it must be paid. Paragraphs A and D. (27A10) on page 11. Any sums received by the authority by way of penalty under the section shall be paid into the consolidated fund. It's a very important point because the destination of the redress payments was not the consolidated fund. And section 27E on page 14 provides for an appeal against the penalty. And the court may quash the penalty, substitute a penalty of a lesser amount.
Yes, the grounds on which you can do that is set out in subsection 4.
And C is the relevant paragraph.
Can we just have a look at that? You say you rely on 4C.
Yes.
Is that getting at timing?
No. it goes broader than timing, because once I've got a timing issue, then I'm back into 3.
Well, the 3C looks pertinent. I was simply reading 4C, and I have to say my initial impression of it is that it's getting at how soon you have to pay, which appears to gain some support from 3C.
But subsection 6 implies that the court has power to substitute the penalty of a lesser amount.
Yes, but we're not there's more than one ground in 4. In particular, ground B.
Well,
I mean, at a rough read, 4A is ultra vires, 4B is procedural irregularity, and 4C is timing. I mean, is there
none of those read that way enable the court to impose a lesser amount.
Well, it might, if it decides that it's unreasonable to require the penalty imposed to be paid by a certain date. It could say that a reasonable amount to be paid by that date is a lesser amount.
And that
it could say the same amount over a longer period or a lesser amount over a shorter period.
Well, that means that I have to bring in a claim under 3C and 4C to get to a lesser amount. But that has been done. Well, yeah, 3B allows the court to substitute a penalty of such lesser amount as soon as there's a timing issue. So, and once I have appealed, then the penalty isn't due. Subsection 5.
It's still been imposed. Just
It's
not due if you've appealed.
It's not due and payable until you've got the result.
Can I ask you about section 27B?
Yes.
The statement of policy with respect to penalties is part of the regulatory framework that Parliament has enacted, isn't it?
Yes.
So that the considerations published by the authority in their statement of policy presumably represent something of what the legislature has indicated is appropriate. I mean, the legislature says the authorities should publish a statement of policy about the imposition of penalties and comply with it. That's part of the legislative framework.
Part of the regulatory framework, because I don't think Parliament has trammelled the way the regulator can use its powers.
I mean, it would be presumably subject to some sort of judicial review if the authority published a policy which was irrational,
Yeah.
or otherwise capable of judicial review?
I think there may very well be a question as to whether the regulator was doing in entering into these settlement agreements exactly what it had indicated it would do under its policy statements. But it certainly had power to enter into these arrangements. And these arrangements complied with the requirements of Section 27A in relation to £1 and not in relation to any more. And perhaps it would help if I went through these notices and showed you how they related to the statutory framework. So in the supplemental bundle, tab 4, at page 101,
So this is the latest one of 4 settlement agreements, isn't it?
this relates to the complaints handling.
Yes. So there were 4 different settlement agreements.
There were 4 different settlement agreements,
This is the last one.
and they are basically in the same format.
Yes. There do seem to be some differences between them.
There are, but they're not. And your ladyship will appreciate this is the one that is most important to me. What you have at the beginning of tab 4, page 89, is the settlement agreement itself. Then at page 101, we have a notice of intention to impose a penalty.
As I understand it, this is a document that is appended to the agreement. It forms part of the agreement.
Yes. And the regulator then publishes this. The notice of intention beginning at page 101, that gets published.
And this is what fits with section 27A subsection 3, is it?
Yes. So this notice of intention to impose a financial penalty pursuant to section 38(3), that's the Gas Act, and 27A(3) of the Electricity Act. And then if we go to paragraph 6.2, we see that the authority sets out the amount of the proposed penalty. And that the regulator has distinguished sharply between the £1 at 6.2 and the 18 million at 6.3. Paragraph 6.6 is notice of the intention to impose the £1 penalty. And at 6.7, the authority invites representations in respect of the penalty.
This is the only notice that was given pursuant to section 27A3.
Yes. And your lordship, your ladyship will appreciate that by the time this agreement is entered into, the idea of a penalty has gone.
Well, that's why I asked you whether there was any other prior notice. In 27A3 could be read in a slightly different way, that in the sense that the first that the regulated person would get to know of anything would be the issue of a notice under 27A3. They would then have the opportunity to make representations or objections. And then the authority would decide what penalty to impose. This seems to have taken a slightly different course. I'm not saying it's wrong, it's just this seems to have been a process of debate first leading to this notice.
Your lordship has it exactly right.
Yep.
It's a process of debate and negotiation that is gone through. And there is then an agreed settlement.
Yeah, but it was the whole thing wasn't kicked off by the regulator saying, well, we're thinking about imposing a penalty. It seems to. How did it start?
Well, they wrote a letter saying, we think you're in breach. And there were then discussions.
And is that letter in the bundle?
I'm sure some of those are in the supplementary bundle.
Okay.
Just on your point, it may make no difference, but when you say by the time we get to this agreement, the penalty is gone.
Yes.
When I looked at the main body of the agreement, which, as you said, starts at page 89, it doesn't work quite like that, does it? Because it's all contingent on approval by the relevant committee of the authority.
That is.
And in fact, that agreement seems to contemplate at least the theoretical possibility that the authority could take a different view.
Yes. But it is a theoretical possibility.
Well, I don't know about that. It contemplates that possibility. I'm not. I said at least a theoretical.
Well, you wouldn't. If you're the regulator and you want people to enter into settlements with you, and it's quite obvious the regulator does want people to enter into settlements, you don't enter into agreements that are fatuous.
Well, there's some. Well, I'm simply saying there seem to be some rather detailed provisions in the main body of the agreement.
It's an agreement.
Catering for just that possibility.
David, tab 20, there's a letter. Tab 20 in the
Tab 20 in the supplementary bundle.
prior letter.
Thank you. Tab 20, page 204.
So this relates to the settlement that subsequently involved the payment of 18 million, as I understand it.
I think that's right, yes.
If you go over the page,
It probably answers my Lord's question to you as well, doesn't it? That at some point it was thought that there would be a higher penalty
Yes.
of 23 million with, as it were, discount for early settlement, and then the possibility, I'm looking at 205, bottom of 204,
Yeah.
205, and then a discount for discount for early settlement, it looks like, from the 23 million. And then the possibility of redress payments to the value of 18 million minus the £1 penalty, which you say is where we ended up.
Yes. You'll see there that the
But I think it's implicit that if there was the possibility of a, on the table, shall we just simply say it would be put on the table by the regulator of a higher penalty than 18 million.
yes, yes, on the table, not actually imposed,
No.
and it wanted the 18 million to go to consumers, as we see in page 205.
Well, it was prepared to consider it.
Well, it then considered it and it entered into the agreement and it issued a notice of intention and then it issued a final decision notice. And
Is the final decision notice the document you took us to earlier?
it's at tab 8. Yeah. I'm going to go through it in a moment.
Thank you.
I was at I was on page 119
Yeah.
at paragraph 6.3. I think I've done 6.5. It considered the penalty to be reasonable. And as I said, 6.7, it invited representations, but only with respect to the penalty. And then at SB 8, page 166, you see that this is notice of the decision to pay. And again, paragraph 1.5 sharply distinguishes between the £1 and the 18 million. Paragraph 6.1 on page 183 is where we see the imposition of the penalty of £1. And then at 6.2, it specifies when the pound has to be paid and sets out different dates for the payment of the 18 million. paragraph 6.3 explains how the 18 million is to be used. And at paragraph 64 of the FTT decision, in the core bundle, at tab 12, page 101, the FTT confirms that the 18 million was used that way. So our submission, the the statutory requirements for a penalty were only met with respect to the £1. And the documents I've just shown you relate to the complaints handling, but all the other documents do the same thing. The footnote 6 to our skeleton argument sets out the references. And we say it follows from that the 18 million consumer redress cannot have been a penalty. It's a very odd thing that the regulator says this is not a penalty. We think £1 is reasonable as a penalty. We want consumer redress, paid for the rest. And the revenue can turn up and say they're not what the regulator thought, they're something totally different. It's a bit arrogant of the revenue to think they know better than the regulator what it is that the regulator is doing. So in our submission to compare the agreed redress payments with imposed fines and penalties, or agreed fines, as in Von Glen, or the penalties in McKnight, is like comparing an orange to a Tuesday afternoon. They're not comparable because the one has roots in the supplier-consumer relationship and the other does not. And in our submission, an instinctive answer to the question, are these payments rooted in the consumer-supplier relationship deductible? In our submission, the instinctive answer is yes, or it ought to be yes. And these payments, at the very worst for me, have a dual character. They're undoubtedly rooted in the consumer-supplier relationship. there is no other source for them. So if they do have some sort of duality, it is necessary to recognize the essentially commercial characteristic of them, which is lacking with a conventional fine.
I mean, is your submission, in putting it in a slightly different way, which you haven't at the moment, but you're saying that these payments were not in lieu of penalties, that they're in lieu of a consumer redress order?
Consumer redress orders came in rather late in the day. So they came in 2014. So they didn't apply in relation to some of these settlement agreements.
As I understand it, it's not said that they applied at all. All the settlement agreements were made on this other basis, not spelt out expressly in the statute.
That is right, yes.
Okay. But I think my Lord's question is still one that we might think about, which is if a consumer redress order was made, what would the treatment of that be? Now, I think I know what you would say.
Well, I would.
That's why I asked you whether it was, in essence, what you were submitting.
Sometimes over the years when I've appeared here, I've been told, we're not writing a book, Mr. Goldberg. We're deciding the case. Well, a consumer redress order is clearly intended to compensate for a trade wrong as between the supplier and the consumer. If you take a parking fine, for example, that's got absolutely nothing to do with the relationship between the consumer, the customer of the delivery company, and the delivery company. The relationship there is a completely different relationship. So we know that damages for libel are deductible so long as they're part of the trade, as in the Herald and Weekly Tribune case. So consumer redress is just a form of damages.
Just going back a moment, when you said at worst there was a dual purpose.
No, a duality. I didn't say dual purpose.
Well, could you just elaborate on what you might accept that duality was?
Well, if you say these payments in some form or another have the character as a penalty, which I don't accept, but if it is said, I say they also have the character as compensation to my customer for a trade wrong.
I see.
And then it may be that you have to ask, which character trumps the other? If there is a rule that a penalty is non-deductible, am I to regard this payment as a penalty, or do I regard it and as compensation. It's got both characteristics. My submission would be that the commercial characteristic trumps the penalty characteristic. And the reason why that is so is that I have to find the true profit. And if I have a commercial outgoing which is not recognized, I cannot be finding the true profit. If I go back to the FTT's decision and show you a bit more of the facts, because the redress payments were made by Scottish Power for the reasons set out by the FTT at paragraph 35. And that sets out at A, B, and C its reason for entering into the settlement agreements and making the payments. And then at paragraphs 108 to 119, we have some findings of fact. And at paragraph 120, they start discussing the concepts of penalties and punishments. And at paragraph 128, they say it seems to us that we should not try to interpret Lord Hoffman's words as if they were in a statute, but with respect, that is what everybody has been doing in this case. They're addressing the question, what's meant by punishment and what's meant by penalty, and these are not statutory questions. You will not find them in relation to the computation of profits anywhere. And to allow oneself to be diverted from the words of the statute is a mistake. We have to interpret the sections which I'm conscious I have not yet shown you, but I'll finish setting out the facts. And then there is an important passage, paragraph 161 to 172. in which the FTT makes findings as to what our trade was, how were we conducting it, and all these findings show that, as a matter of fact, the expenditures were wholly and exclusively for the purposes of our trade. So 171, they say, thus on the basis of our conclusions as to the trade conducted by SPEL, the expense of the compensatory redress payments was incurred wholly and exclusively for the purposes of the trade. We found that the other payments were not deductible on policy grounds. If we're wrong, we would find that Section 54, that's the wholly and exclusively rule, did not preclude their deduction. So they put the whole question on the matter of whether there's a policy that you can't deduct something that's in lieu of a penalty when there never was a penalty. When by the time I'm bound to make the redress payments, the threat of penalty had gone away, so long as I made the payments. And we can tell from paragraph 119 of the decision that the redress payments have the same purpose, as far as we were concerned, and the same commercial background. And I might add, the same regulatory background. I won't say that they had the same regulatory episodes, but they had the same regulatory background as the redress payments. And all of them were paid to recognise harm to consumers in the commercial arrangements between them and their electricity supplier. And that's true even though some of the redress payments went to charities for the benefit of consumers generally, or to vulnerable customers. They still recognise trade wrongs and are paid to put them right.
So, have I understood this correctly? That at the time, at the relevant times of the breaches by Scottish Power, there was no statutory ability on Ofgem to impose a consumer redress order.
I thought that was the case for some of the earlier payments.
I think that for the complaints handling, for part of the period, there was power to impose a consumer redress order, but it wasn't done.
But even when, okay, even in respect of the time when it was not possible as a matter of statute, the guidance that the regulator was following did refer to consumer redress orders or consumer redress. I mean, the term of consumer redress is used liberally throughout the documents in an informal way.
Yes. I can't tell you off the top of my head whether the guidance referred to it. I'll find out over the short adjournment. I might take instructions. We need to check that.
Yeah.
But
if you were standing up and making your submissions in relation to breaches of the same type that occurred today, you would be pointing to these payments being in lieu of a consumer redress order and not in lieu of a penalty.
That is very possibly so, yes.
Well, it seems to follow from all the submissions you've just been making.
Well, I don't know what Ofgem would have done.
No, but you're saying, as I understand your submissions, you're asking us to draw a clear distinction between a penalty which goes to the exchequer through the consolidated fund and payments which you say arise out of the relationship with a customer, which are designed to remedy detriment to the customer, either directly or indirectly through a payment to a nominated charity.
Yes.
And you, I think, are asking us to draw those distinctions in relation to the facts of this case.
Yes.
And I apprehend that if you were doing it today in relation to breaches that occurred yesterday, when consumer redress orders are definitely on the statutory table, you would in essence be asking us to draw exactly the same clear distinction between penalties and consumer redress orders.
I would if the facts were that a consumer redress order had been made. The reason I'm not just saying yes to your lordship is that even today the regulator might not have exercised his powers to make a consumer redress order. He might have entered into an agreement as we had here.
So, in other words, the introduction of consumer redress orders there's no suggestion that it affects Ofgem's power to enter into an agreement of the kind it did in this case.
Yes.
It's just an enlargement of its powers.
Yes.
Just as a matter of fact, just to clear up that, I understand the 2014 guidelines, which are the ones everyone's been looking at, were brought in after consumer redress orders existed. That's why they refer to them. But there is a finding by the First-tier Tribunal in paragraph 21 that the practice was the same before. So for some reason, they were looking at guidelines after the consumer redress orders came into force. I think that's the explanation, I think.
Yes, I wasn't quite clear whether that finding referred to the guidelines we're talking about. There's two sets of guidance that the LTT discusses, and it's not very clear to me how it works.
But of course, it's the taxpayers' purposes that are relevant here. Why was it making the payment? What purpose did it hope to achieve in its business? I think both tribunals have regard to the supposed purpose of the regulator in imposing these £1 penalties and payments which the tribunals say are in lieu of penalties. It's very hard to understand how they can make that, how the revenue can make those submissions when the regulator has said very plainly, I don't want a penalty. I consider a £1 penalty to be reasonable and sufficient. I want you to pay consumer redress to your consumers. And whether you decide to do it or not is up to you. Various things will happen, may happen, if you don't enter into the agreement with us. But it's up to you to enter into the agreement for whatever purposes you want. In our submission, we shouldn't... The regulator Also, one reason why the regulator is using these settlement agreements is because it wants to settle these disputes. It doesn't want to go through a rigmarole, which requires it to go to court, and on a previous occasion, to go to the Court of Appeal and argue about what size penalty there should be. It wants to secure an agreement.
But do you say that the nature of the payments looked at objectively is irrelevant?
Yes, the purpose, not totally, but largely irrelevant. The reason why I say largely is I think I need to recognize that there is a category of payments which, as a matter of law, cannot be wholly and exclusively for the purposes of trade. The main type that I've been able to identify is payments made in calculating profits. Lord Hoffman explains in McKnight and Shepherd that it is illogical to claim a deduction in calculating profits because you've got a circle. If you get a deduction, your profit changes. So he says that cannot be wholly and exclusively. Lord Reid says something similar in O'Donnell. He says that the question of what your purpose in paying the payment was is a question of fact, but there is then a question of law whether a payment made for that purpose is permissible as a deduction. So some, but not all of the authorities, some of the authorities recognize that the wholly and exclusively analysis is a two-stage analysis, where you first of all ask, what purpose was there for making these payments? Were the payments made wholly and exclusively for that purpose? And as to that, I have findings completely in my favor. And then you have to ask yourself, is there anything in the law which stops you deducting the payment? Because somehow or other, it can't be wholly and exclusively. So I said just now that I'd identified one type of payment. I should perhaps have said I've identified two types of payment, because the second type of payment is the sort of payment that's made in Von Glenn. It is a payment of a fine to the consolidated fund.
So it's, you would not dispute that, for example, the £1 penalty in this case is not deductible as a rule of law.
Yes.
As in the fines in Von Glenn.
Yes. I do. Probably only because I'm not bold enough.
And you accept that that is a rule of law? I think from what you said it is a legal rule.
You might also put it on the basis that it's a rule of interpretation of wholly and exclusively, because, as Mr. Justice Rolat says, it has to be a commercial payment. And Mr. Justice Rolat's references to a commercial payment were picked up in Von Glenn. I don't know. Where two of the three judges say that the payment needs to be commercial. So that may be an interpretation of wholly and exclusively, that it is referring to commercial payments, and if you find something that cannot be regarded as a commercial payment, then, as a matter of interpreting the statute, that is not a payment which can be wholly and exclusively.
I'm not sure I understand that submission. I mean, what do you mean it must be a commercial payment?
I mean, a payment that arises out of the trade you're doing, rather than...
But if you decide, for example, to make a payment to charity and publicise it in order to advance your business, is that deductible?
Yes.
That's not a commercial payment in the way you've just described it.
It's a sort of commercial payment because you've done it to advance your business.
Right. So commercial is given a broad...
Yes, Mr. Justice Rowlatt says commercial in the nature of a commercial payment. Was it done to advance your business? See, my case, in a way, perhaps after all this time of living with it, it would seem obvious to me. But it seems obvious to me. This arises out of the relationship of customer and consumer. You've done wrong. Pay your consumer. It's obviously deductible. Now, when I get to Herald and Weekly Tribune, I haven't got the customer-supplier relationship. The newspaper is putting libels into the open air. It doesn't have any business relationship with the customer, with the libeled person. It doesn't matter whether he buys the paper or not. But it's nonetheless done for the purposes of the trade, because it's in the guts of the trade that you have to make these payments, that you have to do the things which lead to the payments.
See, it does sound like you're looking objectively at the nature of the payment. You've just done so quite vividly.
But the test is a subjective one. Mallory and Drummond.
Didn't sound very subjective, that last bit, if I may respectfully say so. You were asking us to focus on the origins of the payment.
Yes, not just me asking you to do that. That is what Herald and Weekly Tribune says. And
See, I wonder whether your focus on the subjective purpose of the taxpayer is in fact the only string to your bow.
I think not.
I know a dyed-in-the-wool tax lawyer may struggle with that gift horse, but it does seem at the moment that you've been placing a lot of emphasis on the nature of the payments, the justification for them, the destination of them, all of which are objective factors, rather than just how the taxpayer sees them.
Well, perhaps it's the description as the only string to my bow. There are a whole quiver of arrows there. I certainly have to look at the purpose of the taxpayer. In the end, I have to look at the purpose of the taxpayer. So, of course, there are payments of the kind which the taxpayer says, oh, my purpose was to advance my trade by making that payment. It's going to be completely incredible for the taxpayer to say that. And in that respect, the objective facts surrounding the payment are clearly going to be relevant. But I think in the end, the test imposed by Section 54 is whether it's wholly and exclusively for the purposes of the trade. I wonder if we should perhaps look at Maladieu and Drummond. Tab 7 in the authorities bundle. It's page 168 of the bundle. The statutory provision there was section 130A. That is now in section 54 of the Corporation Tax Act. The effect is to exclude as a deduction the money spent by Miss Maladieu unless she can establish that such money was spent exclusively for the purposes of her profession. Words in the paragraph expended for the purposes of the trade, profession or vocation mean, in my opinion, expended to serve the purposes of the trade, profession or vocation, or as elaborated by Lord Davey and Strong & Co, for the purpose of enabling a person to carry on and earn profits in the trade. The particular words emphasised do not refer to the purpose of the taxpayer, as some of the cases appear to suggest. They refer to the purpose of the business, which is a different concept, although the purposes, i.e. the intention or objects of the taxpayer, are fundamental to the application of the paragraph. And you have to ascertain what was the taxpayer's object. That's at letter D. So objective factors are clearly relevant, but the determinant is the subjective purpose of the taxpayer in relation to the business.
But this is dealing with a case where the taxpayer had a choice whether to make the relevant payment. So the payment was for the purposes of the trade because it was buying clothes for use in court or not, as the case may be. We're dealing here with an involuntary payment, however, one the taxpayer has to make. So its only purpose is complying with the obligation. That would be true whether it's a damages claim, which clearly would be deductible, or it's a fine. So you can't look at the purposes of making the payment, can you? You have to look at the purpose, as later cases say, of the conduct the taxpayer undertook, which gave rise to the payment.
I don't really mind which you look at in this case. That is why I got the findings that the entry into the agreements was voluntary, because we are not looking at an involuntary payment here. We're looking at a payment we chose to make to avoid the rigmarole and to protect our business, so that we could...
Well, you chose to make it only to avoid having a penalty imposed upon you.
But the imposition...
Subject to your ability to appeal it.
Yes. Well, I'm not going to abandon my right to appeal. It's a very important part of the case.
But it's not, I mean, to pick up my laws, but it's not as if Scottish Power woke up one morning and thought, hey, it'd be a great idea if we just pay a load of redress to our consumers.
No, they didn't. They thought it's going to be best for our business
faced with a letter that says, unless you agree, we'll impose a penalty on you.
It doesn't stop it being best for my business.
No. I'd be surprised if it was thought to be anything other than best for your business, because otherwise the directors would have been breaching their duties in agreeing to it.
So the objective facts suggest that I can have the business purposes that the FTT records me as having at paragraph 35.
But it would also be best for your business to pay a penalty if it's imposed on you, because otherwise you just become a dreadful delinquent.
But if I had paid the penalty, I would not have been making redress to my customers.
Well, that's a different point with respect. I was following through my Lord's questions to you. Miss Molyneux had a choice. The reality is your clients didn't have they had a choice as to perhaps method, but the whole thing wasn't a voluntary offering on their part.
I'm not going to concede that, my lord. They had the ability to go to appeal, and let us suppose they had advice that they would win an appeal against a penalty. Then it's clearly a choice. And it's a business choice that is made. The authorities sometimes look at the route, as Herald and Weekly Tribune does, and sometimes they look at the payment. At night, in the Court of Appeal, which I suspect my lady might have, but your lordships perhaps don't. Here's a copy I made.
Speaking myself, that's an entirely appropriate guess to make. It would help if somebody had a hole punch, by the way, just out of interest. First rule of litigation is to have a hole punch and carry it.
The cost of the hole punch would be deductible.
Modern litigation doesn't involve paper. Hole punches as well. This shows why David should use tax cases on this.
Yes,
I've got a bugbear about this.
yes. Well, I would have agreed with you, but the rules.
I know.
So the passage I wanted to refer to is at page 851, letters C to E. And the point is that the Court of Appeal in Knight Shepherd is saying that this is all wholly and exclusively. All of these cases just require you to answer the wholly and exclusively question. Uh, So Lord Justice North is saying there's no requirement that it be rooted in the trade. You just ask, was it wholly and exclusively incurred for the purposes of the trade? As I say, as to that, I have conclusive findings in my favour. None of them are, and none of them could be challenged. And in the next paragraph, Lord Justice North makes a point about the accounts. The accounts treated these activities as part of the trading activity. And Lord Justice North is implying that it would be very odd if the accounts treated the activities as part of the trading activity when they weren't. And you will, of course, bear in mind that at paragraph 111, I think it's 111, in the FTT decision, I have a finding that the redress payments were deducted in computing the profits of the relevant trade in accordance with the ordinary principles of commercial accounting.
But I suspect the penalties were as well.
Yes.
I mean, you've accepted that there is, that the mere fact something is deducted in the accounts cannot be enough to satisfy the requirements of the legislation.
No. I have to pass the wholly and exclusively test.
Indeed. And possibly some further rule of law, which you've accepted exists in some respects.
Well, what I'm saying is I'm not clear whether that rule is a rule of policy, supposedly a rule of policy, or a rule of interpreting Section 54 and the meaning of expenses.
Or the interpretation of the legislation justifying or authorising the imposition of a penalty. You shouldn't be construing the tax statute so as to undermine the legislative purpose in authorising the imposition of a penalty.
Well, I find it very difficult to believe that a code as comprehensive as our tax code is would not mention that requirement expressly. We know that when it came to banks paying compensation, Parliament legislated expressly for that. And I submit that it is most unlikely that payments made under a settlement agreement can have a special rule in the tax code relating to them.
Well, I thought you had accepted a little while ago, or at least you weren't, I think, bold enough to make a contrary submission, that the £1 penalty would be deductible.
Would not be deductible.
Why not?
It would not be deductible.
Yes, would not be. Yeah, would not be. Why is it not deductible?
It's not deductible because of Bond Glen. And I'm putting that for myself. There are a number of bases on which I could put that. But I'm going to put it on the basis that it's not a commercial payment. In all the circumstances, you would not describe... The way I put it when I opened the case is, can you imagine this payment being made without the intervention of the regulator? And you can imagine the redress payments being made without the intervention of the regulator.
Do you mean Scottish Power would have just woken up one morning and decided it was a good sunny day to pay compensation to its customers?
It did. We know that from paragraph
Without
6.
law? Without the regulator having written to it and saying, hey, we're conducting an investigation into your claims handling?
Nothing about the 8 million in these investigations. Scottish Power woke up one morning and said, we haven't been as we should have been with our customers. We are going to pay them £8 million.
Yeah, but this case isn't about the 8 million. This case is not about the 8 million.
No.
Yes, I mean, it is... I know you say they should have the same character, but the majority of the payments did not actually go to Scottish Power's customers, or certainly not to the affected customers. They went to customers with particular hardships, and they went to third parties. So asking us to assume that these payments could have been made without any intervention from the regulator is a bit of a step, and certainly doesn't have a factual finding.
Well, I don't think what your ladyship has just said to me is right as far as complaint handling is concerned. Because the bulk of that, as we see from paragraph 61 and 64, went to customers.
I see.
Sorry, can you give me those?
61 and 64.
Yes, it didn't go to... I think qualifying customers were not necessarily those affected, were they?
Well, if we look at the...
Oh, yes. 61.
They were defined in...
Yeah, I can see now. 61.
yeah.
Was there any analysis of whether the qualifying customers had already been compensated by reason of the £8 million write-off of bills?
I don't think there was an analysis of that.
Because if it was, then to some extent it's having to pay twice, which is not what it would do other than as required by the regulator.
When you settle a case, you tend to do it in round numbers. And it really doesn't become recharacterized because you've done some rounding. But in any event, the notice of intention to impose the penalty or the decision to impose the penalty at tab 8 of the supplementary bundle, page 166. Shows that the payment was directed to consumers. 1.6 to make compensation payments totaling up to 15 million to Scottish Power's affected priority service register warm homes discount customers. And they're defined as redressed customers who are domestic customers. And the term relevant customers refers to customers or ex-customers with a live account at any time between 2014 and 2016. And the customers who got it were those who were either were due a bill that became more than 6 weeks overdue between the dates of 1st April 2014 and 31st March 2016, or made a complaint to Scottish Power about an issue arising out of Scottish Power's migration to a new IT system. So it was pretty well focused on people who had complaints.
So does it follow that the 3 million should not be deductible?
No, it doesn't follow, because that too it went to benefit consumers.
No, but if your question was, would the payments have been made without the intervention of the regulator, would Scottish Power have donated £3 million to a charity of its nomination which Ofgem approved, without Ofgem having got involved?
On the findings of fact I have, my submission is it would have been.
Do you have a finding of fact to that effect?
35, paragraph 35, of the, as to why they made the payments.
Well, that doesn't say this was a charitable donation that they were planning to make anyway, or anything like it.
It doesn't, but it says they had business purposes for making the payment.
That wasn't the test that you asked us to focus on a few moments ago that I was putting to you, which was, would these payments have been made without the intervention of the regulator?
And I'm saying, when you look at those findings in paragraph 35, you see it is perfectly possible that those payments would have been made without the intervention of the regulator, because C, settlement tended to compensate and could, where possible, be directed to those who suffered harm. SPRERL preferred to make payments for the benefit of consumers rather than paying money to the Exchequer. And when it paid to the charities, those charities were going to benefit people who were in difficulties with their electricity supply. So,
but they could have. That's not people. They are not people, certainly not exclusively, who had suffered harm as a consequence of Scottish Power. I mean, they're just payments to a charity that acts generally for people, presumably up and down the country.
I think that they were in Scotland.
Well, that's a country as well.
Well, you can expect the supply by Scottish Power to be mainly to Scottish people, not entirely. Companies do make donations to charity. And these were specifically chosen charities. Even if I were wrong on that, my clients are entitled to have the payments that were compensation judged as payments that were compensation. The Upper Tribunal says, oh, well, we look at everything in the round. That is not what the law is.
Yeah. I mean, on that, the FTT found in your favour, but only as to around 500,000, not as regards this.
it's very puzzling as to why they found us to 500,000 and not as to the 15 million.
Is there any discussion of that? I think it may have passed me by.
I don't think, well, yeah, there is. But they don't explain why the one is compensation and the other not, actually. I don't think they do.
Paragraph 156.
Thank you, my Lord. Yeah. The reasoning at 1561 as to why the payments aren't compensation eludes me. I'm afraid I don't follow that reasoning. Particularly when the decision notice says that the purpose of the payment is to make compensation payments.
You're saying it's compensation in a broad sense. It's a class compensation.
Yes.
Sort of thing you encounter in competition law these days.
Yes.
Where you have class actions. Somebody in the class may not have actually suffered any loss personally, but therefore part of the class, so they get something.
Yes.
It's a broad axe, I think, is the expression that is used.
Yes. Well, that's...
Yeah. You've tantalised us with the Court of Appeal in McKnight.
Yeah.
Are we going to sort of head in that general direction at some point soon?
Probably after lunch.
You're going to sort of play for the lunch break?
I thought I might. But, I think...
Perhaps we should fit in a few sort of overs of quick bowling before lunch then, just to see how...
Well, I feel I've been batting against fast bowling all morning. So.
Not necessarily. It's often the case that people assume questioning is hostile.
Yes, I know. I've been told before that's a mistake I mustn't make.
Where are we going now?
Well, I think we're probably going to McKnight.
Thought we might be.
Before we go to McKnight, I'd like to go to Winston Finzi, which is in tab 12 in the authorities bundle. And the reason I'm going there is because the Upper Tribunal said that McKnight and Shepherd, the ratio of McKnight and Shepherd was that penalties or payment in lieu of penalties were not deductible. And Winston Finzi shows us that it's not binding authority for that at all. And the relevant passage is on page 269 of the bundle, starting at paragraph 59 in and what is being said there is that it's only the ratio of the decision which establishes a precedent and not obiter dicta. And there are valuable passages about what constitutes the ratio. So first of all, you shouldn't take the case as authority for a proposition that was not argued in it.
Where exactly are you taking that from?
It's really the end of 62.
I see.
I mean, do you have a case, the ratio of which is, what does the ratio of the case mean?
This is the case I have.
Right, okay.
But the last sentence of paragraph 62, it's a mistake in these circumstances to treat what Lord Sumption said as authority on a point that he did not need to and did not address.
And did not.
And did not address.
Yeah.
Lord Hoffman did not address the question of payments in lieu of a fine or in lieu of a penalty.
Well, he addressed them, but he didn't need to, I think is what you actually say, isn't it?
Well,
No.
you're. I think you're saying I thought you were going to make a different point. You're actually saying he did not address payments in lieu of penalties. That must be right.
Yes.
I thought part of your case was that while he addressed payments of penalties, even that part of the decision or his analysis was not part of the ratio.
You're right.
Yes.
Yep.
I said both of those things.
Yep.
Yes.
Yeah.
And so it's all very interesting, but doesn't determine the outcome of this case.
So we don't need to go to Matt Knight then?
Don't need to go to McKnight.
But on which basis of the two reasons you've given us is his Lord Hoffman's decision on penalties not part of the ratio? You say it either wasn't argued or it's a point he did not need to and did not address.
Both of those.
But he did address the question of penalties.
He addressed the question of penalties, not in lieu of penalties.
No, I agree, but at the moment I'm just talking about whether his decision on penalties is obiter or not.
It's obiter because the question of what was happening to the penalties was not in issue.
Right. That's a different ground then. The two grounds you've given us are it wasn't argued. Was it argued in
No, it was absolutely not argued.
I think by the time it got, if I recall, by the time it got to the House of Lords, the issue in relation to the penalties themselves was not before their lordships.
It was dropped in this court,
Yeah.
in this room, actually.
I'm very impressed you remember the room after quite a few years.
Well, I remember it because we were set down for 2 days, and when we came in, Lord Justice North said, you've got a day. And I said, well, I don't think a day is long enough for this. And he said, oh, we don't even know if the Revenue are going to try and defend this judgment yet. So that was a rather encouraging beginning.
Times change.
Just going back to, we just take it as read that Lord Hoffman was not talking about payments in lieu of penalties.
Yeah.
He did, at least in his decision, and hard to say, he did, as part of his reasoning, talk about the penalties and their tax treatment. So you need to persuade us that in the modern way of describing ratio as, is it effectively an essential or preferred part of the reasoning, why is his discussion of penalties not part of the ratio under that test?
Well, you can take out the discussion of penalties altogether and the judgment still makes perfect sense.
Well, you'll need to show us.
So the discussion of penalties begins at page 179 of the bundle.
Well, you've done, I say, extremely well fending off the fast bowling just before lunch. I did win a bet with myself that we might get to open it before 1 o'clock. But should we resume at 2 and actually start fresh with it?
I'm very happy to do that.
How are you doing generally?
Generally, I think we're...
Sorry, in terms of time anyway.
I don't think bad light is going to stop play. I think I will finish before tea.
Thank you very much. All right, 2 o'clock.
All right.